Hello and welcome to this webinar on COVID-19, lease renewals and rent reviews. I'm David Sortel and I'm joined by Neeraj Moda. We're both barristers at 39 Essex Chambers, particularly undertaking work with commercial leases and commercial work. This webinar comes about because of a number of inquiries and cases we've had, particularly dealing with COVID-19 and lease renewals, as well as rent reviews. We've all become more used to the new normal, but what we are seeing now is a trend to trying to crystallize and encapsulate that new norm when it comes to lease renewals and when it comes to determining a new rent. So first of all, we're going to be looking at what to look out for in a rent review, the evidence and tactics that might be used. I'll then go on to consider the types of clauses that landlords and tenants might wish to insert when it comes to a lease renewal, either a negotiation outside the Landlord and Tenant Act 1954 or one which is being disputed within the provisions of the 1954 Act. I'll then go on to consider whether or not the Landlord and Tenant Act actually does allow you to insert COVID-19 clauses into a lease renewal, and briefly cover what's involved in a dispute of that kind within the purposes of the Act. Then Neeraj will then go on to consider turnover rent, something that's received quite a lot of press lately when it comes to issues involving commercial leases, and he'll look at the problems and the concerns when it comes to negotiating that kind of provision for rent. So I shall now hand over to Neeraj to consider rent reviews.
Thank you, David. So I'm going to look at firstly the effects of COVID-19. Perhaps old ground, we all know roughly what the effects have been and what the uncertainty that has been caused is and how it might impact on rent reviews and developments in landlord and tenant relationships going forward. I'll then cover some areas of what to look out for in a rent review clause and consider timing and other arguments that landlords and tenants might wish to raise. So the effect of COVID-19, in short, has been to create huge uncertainty within the market, and not just uncertainty which arises out of a single economic shock, but ongoing uncertainty as the months progress. There's also, as we know, a possibility of further shocks after the 31st of December, depending on what happens with the Brexit implementation period. The reduced trading on the high streets and in retail and leisure centres means that rents are down, landlords are suffering because their lenders are knocking on the door, and there have been significant concerns on the part of landlords because there hasn't been direct assistance given to landlords as there has been to other businesses that employ many employees that have been furloughed, for example. So many businesses are suffering, landlords also are suffering because they can't retake possession easily at the moment either. And there are concerns that this uncertainty will continue. There may be light at the end of the tunnel in the sense that market uncertainty and the guidance that RICS published on market uncertainty has now begun to dissipate, and it's clearer that certain industries and certain premises, for example, large shopping centres or supermarkets in particular, and premises within the healthcare industry haven't suffered from uncertainty in the same way. So it's a good point to bear in mind depending on the industry or sector in which your landlord or tenant is in. And there have also been a number of concessions and transactions which are now providing valuable comparable evidence for valuers and for surveyors when they're deciding what the rent should be upon review. It's important to bear in mind the purposes or the twin purposes of a rent review clause, and the courts do bear this in mind very clearly when interpreting rent review clauses and the machinery of rent review. And the decision of Sir Nicholas Brown Wilkinson in the British Gas case is worth repeating. He said there that there is really no dispute that the general purpose of a provision for rent review is to enable the landlord to obtain from time to time the market rental which the premises would command if let on the same terms on the open market at the review date. The purpose is to reflect the changes in the value of money and real increases in the value of property during a long term. So the key is focusing on the market rental value of the premises, not allowing a landlord to get the upper hand by bumping up the rent because it wants to, or not allowing a tenant to haggle for concessions which wouldn't otherwise be offered or available given to the hypothetical willing lessee. But the purpose of approach does mean then that a landlord often starts on the front foot, because the courts will strive to give effect to a rent review clause and give commercial effect to rent review clauses. The tenant's main weapon in this situation is really timing of the rent review if they can preempt the rent review, and if it's, for example, an upwards or downwards rent review that allows them to initiate or trigger the rent review provisions. And also, a tenant may be able to capitalise on uncertainty in valuation. There's a lot of uncertainty, as we've mentioned. The key points here are that not all leases are equal. What are the main features of a rent review clause? Well, almost all rent review clauses or machinery will contain a date for rent review. Normally it's every 5 years, particularly 10 or more, leases for 10 or more years, and usually there's no controversy over this. But of course, not every lease is going to have a rent review clause, and the courts won't imply a rent review clause if there isn't an express provision. Also, not all rent review clauses are equal, because it may be that a landlord only can trigger the rent review, particularly with upwards only rent review clauses, which represent a bit of a free hit, you would have thought, for landlords, particularly in the current environment, where the rent can only go one way. And courts have been unwilling, it's fair to say, to invalidate notices that trigger rent reviews, only really where it's clear that the rent review can only be triggered by one party, or that its terms require that notice has to be given a particular way, courts step in. Or the different methods, I've already dealt with a couple which are upwards only or upwards or downwards rent review. There may also be reference to RPI or linking rent to turnover, and I'll come on to that more towards the end of the webinar. And finally, there are dispute resolution provisions, and it's important to bear in mind each of these features. As I said, all rent review clauses are going to be different, and even if they're working off a template or a precedent. The main things to look out for then to rent review and rent review machinery are, firstly, the date for the purpose of valuation. It will usually be the date that is provided for in the lease for the rent review. It won't be a floating date, so it won't be the date on which the rent is to be determined, for example, but it always depends on the clause in question. In Glowfield, the rent review clause provided that the revised rent was to be the open market rental value at the time of such determination, the annual rental value in the open market upon a lease for a term of years, certain equivalent to the number of years then unexpired. And the Court of Appeal held that it was contrary to the whole purpose of the rent review provision that the revised rent should be fixed by reference to a date of determination, which could be much later than the start of the rent review period. But everything depends on the rent review clause. And it may be arguable that the valuation should be the date of determination, which then opens up a whole number of arguments for landlords and tenants, particularly if the rent review date falls before the lockdown in March 2020, but the review is carried out much later or in the midst of the current uncertainty. And so it may be helpful for tenants, particularly with reviews that should have taken place or were due to take place from the end of 2019 onwards, to be able to argue that the date of determination should be slap bang in the middle of the pandemic. It's also been held that evaluation should not take into account transactions after the review date, because it's only really the circumstances at the review date that are critical, because that is when the lease provides for review to take place. So a hypothetical lessor and a willing lessee, wouldn't have known about what was happening in June or July or August 2020 back in April or back in March 2020. So it's fair to say, some controversy over evidence that arises after the date of the review, and whether it's possible, for example, to take into account transactions that have occurred this summer for a rent review that should have taken place or could have taken place as early as March 2020. And I suggest or encourage you to look at the 4 articles in the Landlord and Tenant Review 2009 issue 13, which deal with the authorities and the fact that there isn't actually any authority above High Court level that deals with principles of valuation in lease renewals, or rent reviews, I should say. The one authority that I mentioned there, Sagama, it was held that transactions on comparable properties that occurred after the review date were admissible in a rent review arbitration. And that article, I think, correctly challenges that approach or that principle, and points out that how can a surveyor take into account unknowns, to borrow a phrase that's been made famous elsewhere, when the review date was much earlier than the lockdown period, for example, at the end of December 2019. It's fair to say also that time is often not of the essence in rent review clauses or rent review machinery. You often find that rent reviews take place many years after the first date they could have taken place within a lease, and it's only rarely that a tenant will be able to argue that a landlord has lost its opportunity to review a rent. But it's always worth bearing that in mind, that again, it will depend on the precise construction of the rent review provisions. In First Growth, it was held that notice could not be given at any time not more than 12 months before the expiration of each of any of the following years of the said term, but couldn't be given at any other time. So it had to be given not more than 12 months before the end of a particular year, but couldn't be given later, and a tenant was successful in that case. It's also arguable, and that hasn't been decided yet at a higher level, that if a landlord fails to trigger a rent review, that's it, until essentially at least after the date for the next review has passed. So you can't have multiple or sequential rent reviews. And finally, other arguments that may be raised are, and I'll just pick out a couple of these because we're relatively short for time on this webinar, but it may be that the rent review provisions allow a tenant or landlords to raise their own arguments, perhaps more subjective arguments about what rent might be fair, particularly if there's no express provision as to the method of determining a rent. It will be held that the determined rent should be a reasonable rent, and then landlords and tenants will be able to raise their own arguments about which circumstances and factors and evidence can be taken into account. It may also be possible, and I'd keep an eye on this because I have seen cases that have cropped up and I've been asked for advice on these types of cases where there have been concessions agreed between the landlord and tenant, and the effect to which that constitutes a variation of the lease, which is then taken into account or has an effect on the later reviewed rent. So it's worth bearing that in mind, that there may be concessions or discounts that landlords and tenants have discussed between themselves and agreed, which may well have an impact or bearing on the rent reviews. I'll now hand back over to David.
Thanks very much, Niraj. I'm going to now talk about the actual clauses that tenants may wish to see introduced into a lease renewal. And I think we've all seen things have been a bit different, and from March onwards, life did change. And there we have a graphical representation of what it was like in March, April of this year. So during the initial lockdown period, we saw a number of commercial premises were closed down. I say a number, not all. Let's not forget that many shops actually stayed open. But for many businesses, customers and or turnover was reduced. And even if you had a shopping centre where they didn't have to close down, they might see a reduction in footfall. Even if the business itself was not prohibited, the site may have to be closed, or there might be shortages in the supply chain, or it may have been difficult making the premises safe for employees. And even if it's closed down and then it reopens, it may not be business as usual. And has made it difficult to comply with fairly typical tenant provisions, such as repair obligations and redecoration obligations, because either repair works are limited to essential works, or just more pragmatically, it's difficult to find a contractor. And also during lockdown, it was very difficult to move out of premises. And almost inevitably, if your business was forced to close down, we had to deal with issues as to stay open clauses. All of these points remain relevant because the Covid-19 pandemic has not gone away, and we are facing the prospect of further lockdowns, either nationally or, as we've seen, more localized ones, where certain businesses might have to be closed, or enhanced social distancing measures might have to be taken. And so we're dealing with these leases on a fact by fact, location by location, business by business way. So one thing that we've seen in arguments about lease renewals is whether or not a new lease should contain what you might style COVID-19 clauses that would deal with a situation if there is a future lockdown, either national or local. And these can give the parties greater certainty. It can give the tenant greater certainty, but the landlord also knows what his obligations are going to be. Now, the big concern about these clauses is, do they risk pushing the uncertainty and the problems of lockdowns from the tenants to the landlord? And one argument which has featured front and centre is that the government gave a number of incentives and a number of packages to tenants, which they didn't give to landlords. So why should risk be pushed on to the landlords? The other case is this: does such a clause, if it's appropriately drafted, actually offer more than the existing law does? And there is a line of cases, and John Lewis Properties against Viscount Chelsea is probably the leading modern one. And this is where the suggestion that if you have an Act of Parliament or another form of legislation that actually makes the conduct of a leasehold covenant illegal, then the Act of Parliament or the legislative provision actually trumps the leasehold covenant, at least temporarily, so it can spring back into place if the temporary illegality actually goes away. And that was followed by Mrs. Justice Mummery, as he then was, in John Lewis Properties. He said that there may exist lawful excuses for non-performance of certain covenants. So that argument must therefore cut both ways. If we're codifying what might be seen as the common law to make it clear that it applies, then is the landlord giving anything away? Or are both parties losing flexibility and surrendering themselves to the possibility of some loose drafting? So what are the kinds of clauses that might be encountered when it comes to lease renewal or debates and arguments and negotiations as to a new lease? Probably the most dramatic one that you might see is a provision dealing with rent reduction, either in whole or a reasonable proportion during a lockdown. And the big comparison was with rent reduction, where premises have been damaged or destroyed by an uninsured risk. Now, of course, the point of an uninsured risk is that the landlords can't get their money back, can't get the proceeds back from an insurance company because it's an uninsured risk. But during that period, when the premises are effectively rendered nugatory, then the tenant doesn't have to pay any rent. And so based upon that model, you see proposals that there should be a rent reduction during a lockdown. Now, one point that springs to mind when you see these kind of provisions is the position it places a head lease in, because of course they may not benefit from such a lease. So if there is pressure from a tenant to include this clause, does it mean there needs to be a back-to-back negotiation with a head lessor? So that's something that needs to be borne in mind. Also, it does suggest that the landlord is taking on some of the risk of the tenant's business. Furthermore, is such a clause going to be appropriate in all cases, or, as you've seen, some businesses can continue as normal? Well, the tenant might push back against that and say, well, it's not going to be a wholesale reduction in rent, it's only going to be a reasonable proportion. And there are issues about that as well. Other issues might arise, other clauses are repair obligations, such as whether landlord is prevented from taking steps to enforce repair or redecoration covenants during a lockdown until a reasonable period after the end of the lockdown. And at first blush, this might appear to be reasonable. If the tenant actually cannot repair the premises, then why should they be obliged to under the lease? But I would suggest it's necessary to be cautious about such a term. What if the tenant does not repair and it leads to damage to the freehold reversion or to neighbouring properties, such as if there's a leaking roof or there are problems with support? But almost certainly such provision is going to affect any Jarvis and Harris clause. But the point, of course, is with a Jarvis and Harris clause, if the landlord can go in to carry out the works, then why couldn't the tenant just carry them out in the first place? So when drafting such a clause, you may want to think, What's the aim? What's the purpose of this provision? How is it going to go beyond the laws as it sits? And are we, for example, going to prevent a landlord from seeking injunctive proceedings against a tenant who is simply not repairing their premises in a state of emergency? Yielding up. So tenants might not be required to yield up during a lockdown period. Why? Quite simply, and again, quite practically, they may not be able to get removal vans in, they may not be able to move out the premises, they may not be able to yield up vacant possession. Instead, the lease will provide for a license to be granted for a reasonable period, ending after the lockdown period has ended. And this might seem to be a concession freely given to the tenant. Again, seems quite reasonable. But again, think about the other side of the equation. Could the landlord even get a new tenant to move in during such a lockdown period and begin to pay rent? Is this potentially a provision that could benefit the landlord if, in exchange for having a void period, they are instead obliged to give out a license, which a tenant is obliged to take up, and therefore the tenant is obliged to pay a license fee in respect of? Stay open provisions. And this might be more straightforward. It could be made expressly subject to legality of compliance with them, otherwise simply suspended. But again, I note that would stay open covenants be enforceable anyway? And there's good House of Lords authority, which is on the slide, to say is actually extremely difficult to get specific performance of a stay open provision. Indeed, there's a whole line of case law again saying that even if you sue for damages, then what in fact is going to be the damage to the landlord. I've already referred to the John Lewis case. So this might be an example of where it's good to reword the lease to make it clearer that effectively the law trumps the leasehold covenant, but there are going to be arguments as to how essential it is. There are some points to consider when drafting these provisions. First of all, what is going to trigger them? Is it going to be a lockdown? And if so, how do you define a lockdown? Is it going to be enhanced social distancing? But does it mean we're not going to see the tenants going back on to normal rules, so to speak, for quite some time? Another point that requires careful and clear drafting is to consider whether the obligation is only suspended. So, for example, the rent might be suspended, but in fact this payment is still due. So when the lockdown ends, then all the money that accrued during that period is still payable. Or are we going to see the obligation discharged altogether? So effectively less rent in total was payable in respect to that period. References to the term reasonable. Well, reasonable in respect of what? And if there is a debate as to what is reasonable, then how is it going to be determined? Are we going to look at expert determination, which might be quicker? Are we going to refer to arbitration? We need to then consider an arbitration clause. Or are we going to go to court? And as many of us know, the county courts are having a bit of a problem at the moment with the backlog, whereas the high court things are moving far quicker than we might otherwise expect. So just bear that in mind. Or do we want to be arguing about how much rent was due for a quarter or for half a year long into the future? And if we don't, what kind of dispute resolution provision do we want to introduce into our lease? So we have those arguments about the actual clauses themselves, but can we have them within the confines of the Landlord and Tenant Act 1954? If you have an unopposed lease renewal, or it has been opposed but the grounds of opposition have been rejected. And of course, parties can agree the new lease will contain COVID-19 clauses, but does the court have a power to order them to be included as part of the new lease? And we've seen cases where tenants are asking for these kinds of concessions to be made. Principally, we're looking to section 35, terms other than that of duration and the rent payable. Immediately, the question mark is, of course, if we're arguing about rent reductions, are we instead looking at section 34 of the 1954 Act? But if we look at section 35, we're looking at provisions such as maybe agreed between the landlord and tenant, and that trumps everything else, or is maybe determined by the court. And if it's determined by the court, then the court has regard for terms of the current tenancy. and almost certainly the current tenancy is not going to refer to COVID-19 specific provisions. And the leading case remains OMA in City of London Real Property Company Limited, where the landlord wanted a clear lease. At first instance, it was held as a perfectly reasonable thing to have, but the judge at first instance's decision was overturned on appeal, both the Court of Appeal and in the House of Lords, because it was going to affect the balance of security and risk as between the parties. And a Court of Appeal and a House of Lords rejected such a radical change to that balance of rights and responsibilities. But the purpose of the Act is not to ossify leases. The House of Lords made a number of comments about having regard to the terms of current tenancy, the burden of persuading the court to change the terms of tenancy resting on the party proposing the change. The change must be fair and reasonable and take into account the position of a sitting tenant. There must be good reason, based on the absence of agreement on essential fairness for the court to impose a new term against the landlord's will. But that doesn't really steer us when we're steering in quite unnavigated territories where we have a COVID-19 situation. And I've noted here, again, a decision which Justice Sales' event was, but courts generally not exercise discretion to change the basic parameters of commercial arrangement between landlord and tenant. But that hasn't stopped courts from changing the leases when there's been a change in letting behaviour, such as, for example, in Blythewood Plant Hire Limited, when upwards only rent review clause was inserted. Judge in that case said that two-way clauses were virtually unknown. Well, they are much more common now, so the case might well not be decided in the same way. Leases do change over time and do require modernisation. And COVID-19 clauses, I have to note, might also reduce the overall rent payable. If the balance is shifted towards the tenant, then there's a good argument to say, should the rent go down a little? I would suggest that these are likely to be decided on a case-by-case basis. Numerous factors to consider, such as, for example, location. A shopping mall is going to be different to a retail park. User clauses. So, for example, if there's a very wide user clause, that might have different grounds than if there's a very narrow one. The length of the lease. How much risk is the tenant taking on? But one thing the landlord should always bear in mind, and that's the danger of the tenant walking away. Sometimes you can get too good a deal or too great an outcome in court if then the tenant discontinues proceedings, doesn't take on the new lease. So always bear that in mind. There's a lot to play for when it comes to COVID-19 clauses. There are arguments to be had. I'd now like to hand back to Niraj and to consider the possibility, though, of turnover rent.
Thanks, David. I'm going to deal quite briskly with the question of turnover rent, because again, questions of time, but you can feel free to email either David or myself if there's any questions that you have arising out of what we've discussed so far this morning. What is turnover rent? Well, it's sometimes referred to as a performance rent, and it's an alternative method of providing for the calculation of rent payable under a lease. The standard position historically has been that rents are linked to the value of the premises, whereas turnover rent ties a landlord's returns much more carefully, or much more closely to a tenant's fortune. So if a tenant is successful with its business, as no doubt the landlord would want to see, the rent received by a landlord would increase. And if a tenant's business is failing, perhaps as a result of the pandemic or further lockdowns, or even lower footfall than we've seen so far, or supply shocks at the end of the year or beyond, then this offers a tenant some protection. It's normally not just it's not an entire rent based on turnover. There's often an element of it, maybe 70 or 80% of it would be a base rent, and the turnover rent would apply to anything above a certain sum in turnover that may be predicted or estimated in a tenant's business. So it's often a sum plus a percentage of turnover, and it's often a matter of negotiation between a landlord and tenant. So you end up therefore with a tenant having a turnover rent, a base rent that a landlord can take from a tenant. So there's some certainty as to what the minimum rent is going to be paid to the landlord, and if the tenant's successful, the landlord shares in that success. It obviously helps a tenant because the tenant has better cash flow, and it softens the blow where there are lockdowns or there's reduced trading. And it can assist the landlord as well, because it means that the actual value of the premises is being realised. It means a successful tenant contributes to there being a successful landlord. The other advantages are you can have flexibility. Turnover rent can be reviewed perhaps more frequently than the typical rent reviews in a standard institutional lease. So instead of every 5 years, you might have turnover rent reviewed every year. And it's better to have a tenant that's performing and providing some of its a proportion of its turnover or its revenue than no tenant at all. And this is a question that has puzzled and has been exercising landlords and tenants for the last few months. Better to have premises that are occupied by a tenant than no tenant at all. The disadvantages are, firstly, it's relatively new. I mean, there are many leases, particularly in the retail sector, now increasing in the hospitality sector, that provide for turnover rents. But because it's relatively new, it would represent a radical change, I would have thought, for many leases to now be agreed with turnover rents included. Also, turnover rent can be uncertain. If a tenant's business is failing, that then damages a landlord's relationship with its bank or its lender potentially, and puts a lender even more at unease with a landlord that is not paying its mortgage. There are other questions, and the disadvantages are, how is turnover rent measured? There is some degree of reliance with turnover rent on a tenant being upfront and straightforward with its accounts. Also, how do you calculate turnover rent where a business has very few retail sales, but a lot of click and collect orders, for example? What if there are discounts, store discounts and other concessions or vouchers, people paying with vouchers as opposed to paying with cash? So there are complexities, but I would suggest that the complexities or the areas of argument shouldn't dissuade landlords and tenants for thinking more carefully about turnover rent, and there should be less uncertainty or unease about turnover rent than there have been in the past. One other thing to bear in mind is that if a tenant is getting the benefit of a turnover rent, then a landlord really should get the benefit of the tenant not having the same level of security of tenure that a tenant may have come to expect, and also restrictions on alienation, so that a tenant can't assign or share premises with a business that perhaps has a greater revenue but or lower costs, so that it ends up having a greater profit at the same level of turnover. You can see ways that a tenant might be able to play with those provisions in a lease. So there should be, this view is reflected across the industry, particularly in the retail sector, that there should be more of a partnership or more of a collaboration between landlords and tenants, because ultimately, as I've already mentioned, vacant premises are no use to anybody at all. It may be that we are certainly seeing more queries about turnover rent and parties being more creative than they have been, and as lawyers, it's our duty to ensure that the landlord and tenants properly advise on the type of rent and how rent can be calculated, whether it's a straightforward provision or a rent review provision in the lease. I'll now hand back to David.
So that's what we have today in the webinar, but we of course have collected materials and other resources and articles by members of 39 Essex Chambers of Property Construction and related areas. We have a dedicated section in our website on COVID-19 related issues. And as Neeraj just said, feel free to email us or to contact us with any queries that you might have. If you have any thorny issues over turnover rent or with the Landlord and Tenant Act 1954, we're more than happy to help. Emails are on the slide. Otherwise, you can telephone us in Chambers, or we can set up a Zoom call. Thank you very much for your attention today, and I hope you have a good rest of the day. Thank you very much.